start again. Hey there everyone, my name is Gallucci and I'm going to be speaking to you today on behalf of Texas Country Lawyer. As we all know, divorce is a multi-stage process, and in this video I'm going to try to define each of these stages in a nutshell and therefore better break them down for you so that you can better follow the proceedings as it enters the court. The first is separation. And the key point to remember is that Texas does not, I repeat, does not acknowledge separation. You and your spouse do remain married until the final decree is set. Though you can enter into a separation agreement, and the actions at this stage will inevitably affect the final outcome of the case. So, however you decide to budget your money, however you decide to spend your leisure time, etc., is probably going to affect the judge's decision because it is judgment on your character. But, like I said, you are married until the court enters its final decree. The divorce process officially begins when a document entitled Original Petition for Divorce is filed. This is the second stage. The document officially informs the court that a divorce is being sought and any grounds a party might have in the dispute. For instance, let's say you do not agree with the filing of this divorce and you do not want to be divorced, or you're the one who filed for divorce because your spouse decided to fiddle away the family funds or go have a good time somewhere else, will be examined during this stage. It also details the party's claims and what he or she wants the court to award them in terms of property, and that is not just real estate, that is anything physical, such as photo albums that you don't want to go reprint from Facebook, or your family's Porsche sitting in the garage, as well as child custody. At this point, a party can also request temporary orders, temporary restraining orders, and or a protective order. So, what are temporary orders? This is basically the stage where court takes official control over your marriage and any actions that could result in a long-term effect on either party. And that also includes secondary parties, including your children. The orders issued by the court place immediate control over the relationship, the parties' shared and sometimes individual funds and finances, child custody, and when warranted, financial support while the divorce is pending. And yes, that does happen, so beware. The fourth stage is mediation. This is one of the most crucial points because if approached in the right way, a successful outcome can be achieved and it will save you tons, I repeat, tons of dollars in the end. Do not treat this like an I am right, you are wrong game. Mediation is a process where both parties meet in a neutral setting with their attorneys to discuss their differences. The end goal is to formally resolve the case. So open your ears, put your ego aside, and exhibit a willingness to compromise. Because if you can reach compromise at this point, like I said, it's going to save you stress and money at the end. The more you can settle during this stage, the less time you're going to be spending in a courtroom. The fifth stage, discovery, is a generally based term for different legal tactics designed to gather information on both ends. Discovery is more of an informal process involving voluntary document exchange between both parties, and any information that is consensually passed on between the attorneys. Now, trust your lawyer and don't worry because confidential information that you do not condone being shared is not going to enter the process. If the case can't be resolved or settled, it will be set for trial. Trial is often expensive, it's stressful, and it's risky, which is why I very much recommend settling the bulk of your differences during mediation. Often, you'll get a second chance at settling if you weren't able to do it in the first round. If a judge grant you a second mediation, but that depends on whatever judge is residing over the courts. A trial can take place before a judge or a jury upon request. If you'd rather have 12 people examining your case, then put in a request and maybe that will happen. The last stage is the final decree. Whether there is a settlement or a trial, a final decree of divorce is drafted at the end. This spells out property ownership, not just your physical real estate. As I said in the beginning, that's anything that you own that you cannot part ways with. The children's primary residency, what will be received in child support, and how child rearing decisions will be made in the future. Keep in mind that just because you do not have sole custody of your child does not mean that you do not have any say-so in what that child is exposed to or how he or she is being raised. In some circumstances, the final decree can be modified in future time. If a procedural error occurred in the trial, if the court's ruling was not compliant or equitable in the children's best interests, you can file a motion for a new trial or enter the appeal process. But it is a timely thing. You have to do it immediately because there is a very limited time period in which this can be done. We hope this was informative, and if you have any additional questions, please just visit our website at texaslawyer.com. Thank you and have a good day.